Please welcome Aimée and James.
Okay, so Aimée and I are going to talk with you about preparing your client for a psychosexual evaluation. So to begin with, what are we even talking about when we say a psychosexual evaluation? Before I tell you what it is, who here has had a client receive a sexual evaluation? You've had one in your hand, you've worked with them? About half again, okay. For those of you who have done that, have you received different evaluations from different evaluators? Have some of you done that? And have you noticed that they're different? So sometimes profoundly so, right? Sometimes less so. I'm going to walk you through a little bit of what's in them and help you understand what is the common thread between them, and then some of the differences and what to expect in them. Oops. So a psychosexual evaluation is simply focusing on the sexual and psychological functioning individual. We're looking to examine the person's sexual interests, their attitudes about sex, and their behaviors. And here's that word showed up again, deviancy issues. I left it on purpose because it's always out there. So you know what I mean by that now. We also look for individuals' risk of reoffense in the future, or theoretically of offense in the future, if they haven't offended. So the standard content does vary by evaluator, but basically all the different evaluations will contain a review of discovery or whatever other material is available to understand the history as we know. A thorough review of the client's history, different facets of their social, biological, mental health, trauma history, so on, right? The totality of their history. It'll include psychometric testing. I'll go into what that will mean in a minute. A variety of clinical interviews, sometimes collateral interviews, polygraph testing, looking at their arousal template, trying to figure out what actually turns them on, and a risk assessment. So that's a lot of areas to try and cover, and people can go about it in different ways.
In criminal matters, we're oftentimes seeking a psychosexual evaluation because we know beforehand that we want to get what we call in Washington State a SOSA, or a special sex offender sentencing alternative. But those are probably actually the minority of the situations in which we are seeking a psychosexual evaluation. There's many other reasons why we would get one. We get one because the prosecutor demands them, for the most part. We can't even get in the door to negotiate without one. We need one for a plea deal, and then we use them for mitigation purposes at sentencing, if nothing else. And they do help us figure out what's going to happen to them post-conviction with treatment needs, and perhaps with respect to their custody status in DOC.
In non-criminal matters, there's a variety of ways that this can come to play. Oftentimes we're looking to determine an individual's safety around children or other vulnerable populations. So if there's something that's happened that causes another parent or other individuals to be concerned that this person might not be safe. And vulnerable populations could be other things other than children. It could be a sedated patient, for example. We've evaluated a number of dentists over the years, and with concerns around professional practice being one example. We want to, in cases where we need to determine treatment needs, if there's complex things going on and we're concerned that there's enough complexity that we don't really know what to do, we might move towards a full psychosexual evaluation in order to be able to make sound treatment recommendations. Family law cases, all of you family law attorneys in the room have probably some familiarity with how that plays out. and Mark will talk more about that this afternoon. In CPS cases, they also sometimes can come into play. In my experience, these can be a little bit complicated because if the individual hasn't been charged and there's a CPS investigation and somebody's asking for a psychosexual evaluation, then the individual is in a little bit of a double bind in how much they want to tell you. And being able to negotiate that when they're not wanting to incriminate themselves can be a little bit tricky at times.
There's a question.
Oh.
What's that? Oh, I said she had a question.
Oh, sorry.
What does it take to be credentialed to be an expert to do one of these?
Yeah, so in the state of Washington, I'm not sure if that's mine or yours. In the state of Washington, to be a sex offender treatment provider, it is a license. So once upon a time, it required an associate's degree and then a license to be a sex offender treatment provider. Nowadays, they've changed the standards. One must have a master's or a doctorate and then have a license to practice in mental health. And that could be everything from a mental health counselor to a social worker, clinical social worker, to a psychologist, or even a psychiatrist. So you must have an underlying license, and then also have the sex offender treatment provider license separately. Now we'll get into this in a little bit, but it's a little bit vague when, in some cases, whether or not it requires a sex offender treatment provider license to do certain evaluations. Certainly, we always have the issue in professional realm of whether somebody has to have competence, but from a legal perspective, whether or not the SOTP license is required, the short answer is not all the time, but functionally the expectation within the state of Washington is that the individual have one. Okay, so the first point is review of all relevant documentation and discovery. So we're gonna, if they've been charged, we want to review the certification for determination of probable cause. We want all communication records. So if there's text messages between the person who's being accused and the alleged victim, then we want to be able to see the exact nature of the communications. Any online records, emails, all of this stuff. In order for an evaluator to make a very informed decision, they need to see this information. Victim interview transcripts are also important. There have been times where there was a very sensitive case or two where we had to go down to the prosecutor's office to actually view the videotape itself, because what was happening was the short version is we didn't receive enough information just by reading the transcript. We needed to actually see the video to learn more information. One thing that's happened one time, and I'm pretty sure it will never happen again, when you're sending discovery to an evaluator, do not send child pornography to the evaluator. I've had that happen once, and that was a case where an individual was had a sexual relationship. He was 19 years old, and the person he had a sexual relationship with, I believe, was 14, and they were texting back and forth, and they were sexting, and then the attorney sent me all the text messages, including the naked pictures of the 14-year-old. I cannot possess child pornography, so that's one no. Concealing information here. So I said it can be harmful to the client, and I know this is a difficult one for attorneys, and I am in no position to try and tell you how to do your job. I can give you warnings from my perspective. Some of this information that you might have, the danger in concealing it from the evaluator is that the party on the other side figures it out. That's the primary thing. So, for example, I've had a couple of cases. When we write up our evaluations, they'll include a section in there that lists out everything that we reviewed. Right? You're going to completely detail it. And there have been cases where the prosecutor that received it looked through what we reviewed and said, well, wait a second. The text messages were really incriminating, and I don't see that they reviewed the text messages. And then they pushed back and said, has James reviewed the text messages? And the answer was no. And that's an embarrassing situation to be in, because then from my perspective, if somebody asks me, can you stand behind the evaluation? Well, if there's information that I don't have, I have no choice ethically other than to say, no, I can't. I can review this additional information and tell you what my new opinion is. But my point is, you don't want to be in that situation. It's not a good place to be. Okay, thorough history review. So medical, mental health, marital relationship history, their developmental history, their employment history, education, any service in the military, and their sexual history. That's a lot of stuff. Right? It takes a lot of time to thoroughly assess all of this information, even longer to write it all up in a way that documents it accurately. We're not trying to look for things to discriminate. So there's danger in here, right? Medical history, for example, especially when you think about other things like family medical history. If there's a family history of addiction, things like that in the report could be potentially discriminatory against the client. And a good evaluator will recognize that, and if there's a necessity to put information like that in there, it's written in a way that doesn't invoke that, if that makes sense. So we're broadly looking for functioning, how they're functioning in life, any signs of mental health stuff, any signs of trauma history. We're looking for their life story to develop context for their sexual behavior. So what some people try to do, people who work on the voluntary side of things often do an assignment which is a sexual timeline, which is very useful. But my problem with a sexual timeline and trying to understand a client's behavior is that it's not in context. All I have is, I did this sexual behavior, and then a year later I did this sexual behavior. What was going on for you? How do I make sense of this? And so that's what we're trying to get with all of this. Psychometric testing. So I'll give you 4 main areas: personality testing, mental health specific testing, sexuality, and intelligence. I'll go in reverse order. Intelligence. The biggest thing we're looking for is to document that this isn't somebody that's high needs, that might have difficulty with their cognitive abilities, to where other special things might need to happen in order to assess them accurately. If somebody is very low functioning, then the MMPI, for example, might not be valid to administer to them. We need to make those adaptations. Sexuality, there's a number of scales out there that are well empirically developed that look at patterns of sexual behavior and try to understand the amount of consequences somebody is experiencing from their sexual behavior, whether their sexual behavior is oriented towards coping, whether they are simply engaging in this behavior for erotic gratification, which is totally different than engaging in the same behavior for coping. So testing to understand their sexuality better. Mental health specific testing, these are things we're looking for specific disorders of concern. So like trauma scales or obsessive compulsive disorder scales. Some of these things we administer to almost everybody when we do them at Pacific Behavioral Healthcare. But others are things that if we feel a need, then we'll add it on. Personality testing, think of it as more of a broad umbrella, right? So like the MMPI, the MCMI, tests like that, they're not looking at one domain, they're looking across lots and lots of domains. And one of the things to be concerned about is taking a score on a personality test too much at face validity. This is the biggest error I see people do. Testing does not diagnose. That is a outside of the bounds of professional competence to use a test to create a diagnosis. Tests are data points, and we need to make sense of those data points. So, for example, on MMPI, it is very common that I see individuals who might have an elevated psychopathy score, right? So they think, oh, this guy's a psychopath. He's antisocial. If I tear down into the item level data and I superimpose that on everything else I know about the person, I might find that, well, this elevation is due to their problematic behavior itself, not necessarily to personality features. So it's very important that in the course of this that we seek to understand why there's a certain elevation.
James, just to jump in here,
Yep.
As an attorney, I've never had an evaluation come back with every single one of those those tests in them. And so I'm wondering, as an attorney, can I just trust that the evaluator's picking and choosing the right tests, or have you actually ever heard of getting pushback from the opposing party or the department or a prosecutor about that scenario?
I've not personally gotten pushback. However, I would say that a certain type of pushback is appropriate. If evaluators using tests that aren't well developed and they're trying to hang their hat too much on it, then a pushback is appropriate, right? To challenge the choice of the evaluator and what they're using. I would also say that I personally believe that the attorneys play an important role in being advocates in the process. There's a difference between being an advocate and approaching in an adversarial manner and going after the evaluator and trying to control what the evaluator is doing. That's very different than advocacy. When an attorney, and Aimé's done this, and very artfully so, calls me up and says, look, there's a concern about this case. Here's some information that I want you to know, and can you, would you be willing to consider this as data and do what you need to clinically, right? I'm not trying to control the process. I want to flag something for you, right? That's valuable. That's very valuable.
Are there any of the tests that the lawyers should be trying hard not to let the client do?
None of the ones I listed there. I think the greater danger is not necessarily the test itself, but what somebody does with the test, right? So when people try to take a data point and use it as determinative, they're out of bounds, and people do it all the time. So that what I would say would be the greater one. There's other tests in the process that aren't necessarily psychometric in nature that I have personal concern about, and we'll get to that in just a moment, such as plethysmographs, which I personally think you should not have your clients do. So collateral interviews. Collateral interviews are difficult in knowing how much emphasis to put on it because you pretty much have to assume the vast majority of the time that there's bias present. So if somebody's spouse is being charged with committing a crime and they're trying to reconcile the marriage, they might not, be fully forthcoming and everything. That is what it is. Generally, I prefer to conduct collateral interviews. I'm more likely to do them in family cases, get more context. Partially because we haven't had an investigation, I'm not getting lots of other documentation. I need more data points, and to hear other people's concerns. There's other times where there's other value added. So, for example, a case where somebody's engaging in sexual behavior in their sleep. We could have a whole talk about sexomnia. It's absolutely fascinating. The short version is people actually do engage in problematic sexual behavior when they're sleeping. You can do almost anything when you're sleepwalking. And it happens to be a relatively convenient excuse if it's the nighttime and you're doing something sexually that somebody doesn't like, right? So figuring out what that means and working through that is a really good example of where there's added value with collateral interviews, trying to document in that particular example history of parasomnia behavior. Okay, okay, I'll move on to the next slide. Arousal template or deviance testing, right? So there's psychometric-based testing that's trying to determine what somebody's arousal template is, what turns them on. The MSI is one that Nichols and Linder and Tacoma developed. It's used very frequently here. I've used it in the past. I'll be honest with you, I don't like it. It's not my favorite test. I think that there are some problems with it. Polygraph can also be used as a determination of what somebody's arousal is. If we're looking at their sexual history, we're asking them what their pattern of behavior is. If they're being tested on that, in theory, you can derive from patterns of behavior what arousal likely is. Viewing time. Has anybody heard of the ABLE assessment? A few of you have. So the ABLE assessment is controversial. There are people who love it. I know evaluators in other parts of the country that don't even understand why anybody thinks it's controversial. They just say, it is the greatest thing since sliced bread. Why doesn't everybody do it? Well, it's a little more difficult than that for me. Viewing time is essentially, the look is another assessment. What these types of instruments are trying to do primarily is they'll show images, a number of different images with different ages, genders, so on and so forth. And people cannot, even when they're trying to, there's some research that suggests, change the amount of time they spend focusing their visual attention on things that they are more attracted to. That's the principle behind it. And so you track the viewing time of these different images as they're cycling through, and you notice patterns over time when they're younger, when they're female, when they're whatever, right? And you start to be able to develop, the ability to say their average viewing time for these criteria is longer. Therefore, we can infer that they have more attraction to this group, right? There's good research behind these assessments, and there's good reason to do them. However, they're not bulletproof, and one of my fears is the same as with the plethysmograph, is that they can be misused. That they can be, with the plethysmograph, if you test positive as attracted to a minor, right, then somebody reading that report will naturally infer that you did it. Well, I just told you shortly ago that a lot of people are walking around society not offending people who have attraction to certain things. And so there is a danger in these results being misused. So plethysmographs, everybody know what that is? Plethysmograph is, there's a couple of different ways to do it. Classically, what they do is they put a glass cylinder over the penis of a man. And they show different stimuli, including, it could be audio, visual, or a combination of the two. And they measure blood flow changes as the stimuli change. And therefore seek to determine, based on that, what arouses them and what doesn't. Again, lots of problems with plethysmographs. It's possible that somebody could spike on everything, because anytime you talk about anything sexual, they're just somebody that responds to it all. And it's not even necessarily something that they're particularly aroused by. So that would be a false positive. There's also people who engage in certain behaviors and are able to tune out and just get a total negative. It shows they're aroused to nothing. And there's everything in between. So I don't think they're particularly accurate, and I don't think they're a really great forensic tool. Polygraph, specific incident polygraphs, we're going to ask 4 questions about a specific incident. So primarily if somebody is a denier or denying aspects of an offense, the polygraph goes into, did you touch this person or what have you. Sexual history polygraphs, in comparison, are looking at the broad picture. Other than what you've told us, have you ever touched somebody without their consent? As an example, right? Okay. So ATSA practice guidelines do limit so ATSA is the Association for the Treatment of Sexual Abusers. That's the national organization that sex offender treatment providers tend to be members of. There are limitations on the use of polygraphs. The biggest limitation that we talk about is it is not a determination of guilt. And this is where all the attorneys in the room are saying, damn straight, I don't want my client taking a polygraph. Those things are a piece of junk, right? And I get it. I totally get it. And I can tell you that I'm not signing up to take a polygraph tomorrow, and I haven't done anything that I feel particularly guilty about. The best utility, I would say, for a polygraph is that it provides incentive for people to be open. Right? It's not just tell me whatever you want to tell me, and I'll just take it all at face value, and we'll just go with that. And whatever you tell me, I'm going to put down in my report is true. When matters are this sensitive, nobody's going to be comfortable with that. I mean, let's just be honest. Like, if the safety of your children depended on you trusting whether or not somebody just decided to disclose to me whatever they wanted to, and I was just going to trust that, you wouldn't feel very safe about the well-being of your kids. But we know that polygraphs aren't perfect, and they have lots of problems. So the best utility is it incentivizes people to be honest.
So what James is talking about is using polygraph examinations in the context of an adult who's accused of a crime or is seeking a sexual deviancy evaluation for a different reason. For juveniles, it's a different situation, and it's a different situation as of very recently. I actually sent a client, without knowing that anything had changed, to get a sexual deviancy evaluation or psychosexual evaluation with an evaluator, and this was a 15-year-old kid, and I had mom call me as soon as the child went for the first interview and said, "We don't have to do a polygraph exam. Should we?" And I called the evaluator and I said, "Whoa, this is the first time I've heard this." And the reason is because ATSA, the Association for the Treatment of Sexual Abusers. Yes, just promulgated new guidance last summer about juveniles, and the recommends not using polygraphs for various reasons, that they're unethical because they're not proven scientifically and validated for use with young offenders. The problem, of course, is when you talk to your evaluators, they'll tell you, "Oh, but the prosecutors want them." So then you're in a position where you kind of have to talk your client or their family down and back into getting one. So for the time being, I don't think, for all intents and purposes, in spite of the new guidance or guidelines, anything has really changed on the ground until the prosecutors start to embrace these guidelines. Maybe we need to start pushing them on the prosecutors so that they understand that polygraphs are different for kids. They might understand that to a certain extent anyway, but if they're still demanding them, we have to either prepare our clients beforehand to react to that speech from the evaluator, or we have to convince the prosecutor we don't need them. Question?
So, on the sexual history polygraph, are you better off if your client fails miserably and you're pretty sure they failed because they were not being accurate? Are they better off going to take another one and saying, "Hey, maybe you should be a little bit more honest," or are they better off just doing the failed one and then talking to you about it?
No, the way we do it is we ask them to come in and talk to us. Okay. And then take a new one. And oftentimes, and we'll get to this a little bit, oftentimes people are failing because it's just benign stuff. Even maybe it's stuff that they're embarrassed about, or whatever, and we they just need to dump it all out there. The other thing that can cause them to fail is really poorly crafted questions, but that's another conversation.
Okay.
Yep.
Question: where are those new guidelines found? You mentioned it.
The juvenile guidelines, or they're on the ATSA website, right?
They are.
They have the practice guidelines for adult and juvenile offenders.
Aimée, do they make a distinction among juveniles between younger juveniles and the ones who are like 17, 18?
I don't think so, no.
I think it's minor period.
I mean, of course, common sense would tell you that is, age is not a magical number, right? Like when you turn 18, it's not instantaneous.
And
but
has anyone argued that because juveniles mature more slowly than the law recognizes, that you can use that argument to maybe undercut a poor polygraph for a 19 or 20-year-old?
Up to 25, right? Because we know about neuroscience. I've not tried that approach with the prosecutor, but we're all pretty careful about not turning over failed polygraphs to prosecutors, generally speaking. So, but I think that this is an area that's changing just with neuroscientific research. Polygraphs are probably lagging, but it's a conversation we should all be having to educate the prosecutors, just as we're educating ourselves.
Okay, so risk assessment. Ideally speaking, we're going to use actuarial risk assessment tools, where we can actually look at individuals who obtained a certain score on certain factors, and they've been tracked over time, and we have a body of known reoffense rate, and we can compare scores to reoffense rate. Many of you will know the statistic that is pervasive throughout society, which is that 80% of sex offenders reoffend. I'm sure you've heard that one, haven't you, Amy? Mm-hmm. It is absolute garbage. That is not true. The reoffense rate does vary by score on some of these tools, but I would say that the individuals that I work with, primarily their predicted recidivism rate is closer to about 5%. Of course, I'm only people that are coming to me for evaluation, and those are probably tend to be less risky people, but nonetheless, 80% is not true. So static factors are things that are unchanging. So static 99 is the gold standard for static risk assessment of adults. And these are things that really relate to primarily to their offense pattern and to their age at release from incarceration, and whether or not they, at the time of incarceration, have been in a live-in relationship for 2 years or longer. Those things can't change, right? I can't treat that and change the score. It is what it is. The only way that a static score changes is if somebody reoffends and it resets the score. So it's interesting and it's important data, but it doesn't really help us from a treatment perspective, whereas dynamic and acute risk factors do. Dynamic are things that don't change quickly, but do change. They're long-term treatment targets. Whereas acute factors are more things that are going on right now. They're dysregulated at this moment, for example. They're having a flare-up and they're not doing good. So dynamic risk, when this happens, the acute factors, we need to pay attention to that. But the dynamic risk factors, that's really more of our long-term treatment goals. And then, Amy.
So, as I mentioned before, oftentimes we are seeking an evaluation for a specific purpose, and commonly for us attorneys, we're looking to ask an evaluator to do a SOSA evaluation, which is something specific and dictated by statute, but it's different than a SOTA evaluation, and it's potentially different than an evaluation that you're seeking simply because you need one, or you are hoping to get a risk assessment that's favorable to your client without necessarily determining that your client is particularly amenable to treatment. So James, can you talk a little bit about the difference between a SOSA and a SOTA, which might seem sort of the same on their face?
Yeah, so when we're dealing with minors, the tools, the same general structure exists, right? What we're looking for, minus the polygraph. But the tools specifically are going to change considerably. So, for some of the instruments, there are adolescent versions of them. So the MMPI, for example, you can't use the MMPI-2, you use the MMPI-A, the adolescent version of it. When it comes to risk assessments, there are no actuarial tables for adolescent offending, for juvenile offending, right? We have tools that we know relate to empirically to propensity to reoffend, but we can't give you a probability score. So there are tools that somebody in my position would use to assess and look through their pattern and say, okay, well, here's how they kind of come out on this factor, and here's how they come out on this factor, but I'm not going to give you a score at the end. I'm going to lick my finger and I'm going to stick it in the air, and I'm going to say He looks good enough, right? And it's the same thing with child pornography. We don't have actuarial risk tables for child pornography. We have risk factors that we know for reoffense, but we don't have a table to give you a number. Those are the biggest difference.
Okay.
Okay, so what is required for a SOSA and SOTA evaluation? Well, in the state of Washington, to do either one of these, one has to have a sex offender treatment provider license. And the license implies that in order to work with a sex offender, one must have this license. That's not actually quite accurate. If you read through the statutes, what it primarily states is that the sex offender treatment provider license is what is required to do a SOSA and SOTA evaluation and subsequent treatment. So primarily, there's some other little caveats to it, but primarily this is a SOSA SOTA license. Functionally, however, though, the norm is that anybody who is working with sex offenders will have that license. There are caveats. So somebody who is a high needs client that is not likely to be not very predatory in nature. They might be better served by somebody who's not an SOTP, who has a specialty in, for example, autism, right? And in those cases, you know, people generally, in my experience, aren't going to pound their fists too hard to say this has to be an SOTP, it has to be an SOTP. However, child pornography, for example, also likely, you know, from a legal perspective, probably doesn't have to be an SOTP, but functionally, the reality is it does. Okay, so the state of Washington has dictated what has to be in the SOSA and SOTA evaluations. So the RCW states that the examination must include at a minimum the offender's version and the official version of the facts, the offender's history, an assessment of problems, just problems, the offender's social and employment situation, and we have to report any other evaluations used. The WACs get a little bit more, go ahead.
If the SOSA and SOTA evals are coming before there's been clearly a trial or plea or anything,
yes.
How is there an official version of the facts?
Yeah, that gets messy. So there are times when we have to be a little bit creative. Ideally, we have a determination of probable cause, right? That's where we tend to use as our official version. There are times where so you could not do a true SOSA evaluation without it, right? You could do a bunch of legwork on the front end waiting for the official version, but you can't do a true proper SOSA evaluation until you've done that. You could do a psychosexual evaluation without the official version. Does that make sense? It just won't qualify for use as a SOSA evaluation. Okay? So the WACs get a little bit more specific, but overall, still, I'm not going to go through all of this. Overall, between looking at the WACs and the RCWs, there is still a lack of specifics. There's domains that we have to assess for, but evaluators have a fair amount of freedom to approach it in different ways. And then ATSA also has their own guidelines. So ATSA, you'll see in conducting a psychosexual evaluation, they will ideally include the following. So the ATSA guideline is aspirational. Nonetheless, my experience is that these things, which are fairly close to what's in the WACs, tend to be followed by evaluators. The biggest thing that I would say, in my experience, that isn't adhered to on as frequent of a basis is collateral informants. There are some evaluators who always do collaterals, and there's some evaluators who never do. Okay.
So when you send somebody to get an evaluation, ideally you want a good evaluation, and a good evaluation is completely subjective, right? It kind of depends on what situation of the various ones that we've already discussed, which goal you're trying to attain. Are you trying to get a SOSA? Are you trying to get a SOTA? Or do you just need to get out of this situation with as little damage as possible? And these are some of the things that are going to determine whether or not your client is going to receive a positive evaluation. And I'm not going to read them all, except for that what I'm going to say as a practice tip is that communication is the key. And sitting down with your client for much longer than you think even is necessary to find out what the answers are going to be to all of these questions is the key, because you want to know the universe of information before you let your client go talk to anyone else. And I know that sometimes time is tight and you're rushing to get through things, but the outcome is really dependent on you sending a client who's informed and knows what they're doing over to the evaluator for their series of interviews and testings. You don't want anyone to have any surprises in that context.
Okay, and then what makes somebody amenable to treatment? The primary thing we look to is their overall risk. So if we have those actuarial tables, we're looking to the static and stable risk factors. Okay, I'm not going to read all the factors. Like I said, these are things that are really fixed in time, like their age and the nature of their offense, whether they've had previous offenses, previous sentencing dates, whether there's violence involved, as well as their stable factors. Now, clinicians who have looked into the tables really well, you can actually combine them into one overall risk factor. So you can say based on the combination of their static and stable scores, their overall risk factor is this, right? So as long as somebody is a low risk for reoffense, that is the primary basis to say that they are, it's safe to be in the community. However, there's other factors. Will this person even work in treatment, right? If we try to put them in treatment and try and decrease the propensity to offend in the future, are they somebody that's actually going to work in treatment? Are they going to push back, and they're going to drop out of treatment? They're going to do any number of things that won't be helpful to them or to society. Some of these things include taking responsibility for the behavior. So where somebody's saying, yes, I did this, and you know what, yes, there's some complications in my marriage and my life and so on, but at the end of the day, it's my behavior and I take responsibility. Versus somebody that's saying, well, my wife's a nag and blah, 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 right? That is not taking responsibility in the same way. Desire for treatment. Somebody says, I'm not healthy, my life isn't working for me, please, doc, help me find something that's going to work better. I really want to do this. Those people are much better off. Lack of high needs, so severe mental illness, homelessness, schizophrenia, things like this. We don't want to discriminate against people who have greater mental health needs or struggles, but there are complications that come with such cases that have to be accounted for. Ability to complete treatment. So if somebody doesn't have any finances, then it's something that has to be looked at one way or another. Positive social support system and a lack of negative social support. So they're surrounded by people who are holding them accountable, who are not engaged in criminal activity themselves, and so on, versus the person whose buddies are constantly telling them, you know, you should, you're getting a bum deal, man, you know, that's not helpful. And the final one is the ability to disclose intimate details in treatment. So some people are so closed off that they can't talk about the stuff in their lives that got to them to this point where they're so out of control. To be able to do treatment, you have to be able to talk about your life, even if that means that it's gut-wrenching and there's a lot of tears involved. Okay, Amy.
So this slide asks a question. Well, it says preparing your client for an evaluation, but it presupposes that you are going to send your client to get an evaluation. But I think that all attorneys ask themselves before, can I actually send this guy to get an evaluation? And, you know, I guess the classic setup is, are there bodies buried in the backyard that are going to make the situation a lot worse for your client when they're discovered in the evaluation process? And I think the answer, I don't know if James totally agrees with me on this, but I think the answer is there's some people that you cannot send to get evaluated, and you just have to figure out a way forward and through a very challenging situation without an evaluation. Other times, you don't know whether their body's buried in the backyard or not, but you might decide to send them to get a specific issue polygraph in order to help inform your decision along those lines. And one drawback to that approach is it can get expensive, and everybody can't afford to kind of polygraph shop around, but it can be a helpful way to kind of narrow down the issues and figure out a game plan going forward. The other thing is, you know, we've talked a lot about SOSA evaluations, and I think that there's a lot of pressure. I feel like I have a lot of pressure on me as an attorney when I'm sending a client for what I know is ultimately going to be a SOSA evaluation, because they have to be amenable to treatment. They have to be owning, you know, the vast majority of the conduct, the offense conduct that they're accused of in the official version of the event. And that process is really difficult with many of our clients, right? They're engaged in thinking errors, and you have to spend an even greater amount of time kind of working those people and taking them up to the point where you're ready to hand them off to the evaluator than you are in other contexts where the statutory SOSA requirements aren't necessary.
Okay, so from my perspective, what can you do to prepare your client for an evaluation? Well, encourage them to be open and honest. And that might sound counterintuitive to some, but my experience is that the individuals who come in and are the most open and honest about their past, even if they have skeletons, and I totally understand Aimée's perspective that from a defense attorney's perspective, there might be times where this isn't a good strategy. I get it. But if you're going to get an evaluation, even if there's skeletons in the closet doesn't necessarily mean not amenable to treatment. It might make complications for the prosecutor who now knows this information. That's something that you have to wrestle with. That's outside of my wheelhouse. But when people are hiding, and we constantly know, we get a sense pretty quick, pretty easily, that they're just kind of squirrely, and it's not all adding up, right? And it doesn't go right, and then they end up failing a polygraph, and then there's a domino effect. Whereas somebody who comes in and says, you know, this is what's happened. 5 years ago I did this. And they're an open book. And where, from my perspective, where it's especially valuable is, these are my struggles, these are my mental health struggles. I can tell you about my pain, and I'm not going to hide the things I have sexual shame about. A lot of the things that people are hiding are things that aren't even necessarily offense behaviors or that are chargeable, but they just have shame about. That they did sexual experimentation with a family pet or a neighborhood kid when they were young. These are things that trip people up that they just need to be open with us about. It doesn't make them predatory.
And so our time's running short, so we might not be able to get through the last couple slides, but I did want to make sure to hit on the notion of now you have your evaluation in hand, what do you do with it? And usually we're turning it over to the prosecutor, and we're very nervous about that because if you don't have a denier on your hands, then by implication you have an admitter on your hands, and as the prosecutor, clients are super nervous about this. Why are you giving this to the prosecutor? I admitted all these terrible things, but obviously you have to. And so we always send it with this ER 408 410 letter. And some prosecuting attorneys' offices have policies, right, where they say, we agree, our policy is to not use this evaluation against your client in our case in chief if we are to go to trial, but we'll use it for impeachment. And I've never litigated that issue, so I'm not sure how successful a challenge to using a psychosexual evaluation for impeachment would be. But I've also never had to be in the position of going to trial after turning over an evaluation. I think most of us do not ever want to be in that position. But it's a danger. And I've heard that there are actually some U.S. attorneys take the position that your client can't testify if you've turned over an evaluation, which I don't totally understand that perspective, but I think that it's very perilous if we actually think we're going to have to be putting our client on the stand in a trial scenario when we have an evaluation out there. So to be really careful about how you think through those things. There's a case, a Washington State case, McEnroe, that says you can withdraw evaluations or withdraw any materials that you filed under seal if the judge denies your motion. That's obviously very challenging in the SOSA situation because if you withdraw your evaluation, the court can't rely on it, and then what do you do? So I think it's worth considering whether in the other scenario, I guess that would come into play a lot, would be an exceptional, if you're asking for an exceptional sentence and you need the court to rely on the evaluation. Otherwise, consider not filing the evaluation under seal or otherwise, and just excerpting perhaps relevant portions in your sentencing paperwork or other papers to the court, because there's a lot of information in there that we'd all be horrified to know is going to be in the public domain. That does not solve the problem that most attorneys are probably aware of, where when you turn it over to the prosecutor, you're creating a public record anyway. I've heard some attorneys suggest that they lend the evaluations to the prosecutor or they show them to the prosecutor and then take them back, but I've not heard any prosecutor accept that offer. So we, even if we're keeping them out of the real public record, the court file, we're not keeping them private because we're turning them over to the prosecuting attorney's office. But we're not in a great situation as it is, so we're just making do with the best of a bad situation, and it's good to kind of talk your clients through that so that they understand the ramifications of where that evaluation is going to live and how accessible it would be to people who might want to see it.
Okay, very briefly, what comes after all of this, treatment-wise? Sex offender treatment is not the same across the board. Different providers definitely take different approaches towards sex offender treatment. The prevalent treatment models that are out there today are the risk, need, and responsivity model, the cognitive behavioral treatment model, the relapse prevention model, the self-regulation model, and the good lives model. And within each of these things, different providers are creating their own programs, their own interpretation of them. And if a lot of the treatment providers like me out there are actually doing hybrids of them. So what I would say is that what I primarily do is the good lives model, which is based on the principle that individuals who have whole, healthy lives are less likely to reoffend in the future. However, that doesn't mean I don't bring in principles of self-regulation and relapse prevention in order to ensure the community is safe. I'm not just going to take for granted that this is work. I'm also going to have accountability and monitoring and developing tools to help people understand when they're at higher risk and how to police themselves. sex offender treatment is varied in length depending on the provider, the model they're using, and the offender, as well as how hard the offender is willing to work. So treatment can range from several months to several years. That doesn't give you much to go on other than that there's quite a bit of variability. I will say this final point, that treatment can be inappropriately brief and it can be inappropriately long. Treatment can be brief and simply say, come here for treatment, we'll check you off real quick and efficient, and we'll send you out, and that doesn't work well. And treatment can be long, and people can be strong-armed into staying in treatment, where treatment centers are continuing to make a profit, long beyond what is actually necessary for public safety and for the health of the individual. So, thank you.